Good evening. Happy Sunday, round two. Our boy, Delete did a 2 hour long, no, hour and 47 minute long video. He said about 2 hours. Shows what I get for listening to him. Anyway, I didn't listen to all of it. I came in right about this point, so I'm going to start right about this point, and we're going to go over it a little bit. I do think that I got Chillie's attention. My California bar number is 320086. And Archangel for Truth is a legal genius who has researched carefully the California Rules of Professional Conduct and the California Business Code. For some reason, she also researched the ABA Rules or Codes. I don't know what the ABA Rules or Codes is. The American Bar Association does have model rules, which California has applied some of the ABA model rules, not all of them, incorporating them into California's Rules of Professional Conduct. But, I'll give Archangel for Truth a little bit of credit. Whoever this person is, Archangel for Truth, is a real big Chillie de Castro fan, so awesome. And they're gonna report that. And good luck with that, Sugar Plum, she says. He says, whatever, who knows. So Chillie has found the link to the California State Bar, and he's going to report me. If anybody else wants to report me, there you go. There's the link. You could go ahead, have fun, knock yourself out. I don't care. And he says California has the strictest cyber bullying rules in the country. Interesting. Interesting. Notice no citation there. So, By the way, Chillie, I think you have a bit of a leak. I think you have a bit of a leak in your website, because I'm not there, but it appears you got somebody there who's leaking your stuff, buddy. So yeah. So anyway, this isn't my first go around with I'm going to get you disbarred because you said things I don't like. I went through it with Earl David Warden, aka News Now Houston, aka News Now Community, where he pretends to be his son running the channel. And I think I also went through it with Chauncey Hollingberry, aka Dragonfire Auditing. And I may have gone through it with other people. I don't really know. I've never been contacted by the State Bar for any of these attempts to disbar me. Just so you know, I mean, if you don't want to waste your time filing something that I'm never going to see, really the only way you can complain about an attorney that the California State Bar will care about is if it was your attorney. If you gave that attorney money, if you contracted with that attorney, if you had a reasonable belief that that attorney was your attorney, that's really what it takes. You got to remember that in every case there is a prosecuting attorney or plaintiff's attorney or petitioner's attorney, and there's a defendant's attorney or a respondent's attorney. There's attorneys on both sides, and there may be other attorneys in the mix as well. And generally speaking, at least half of the parties to that suit aren't going to be happy with the other attorney. You know what I'm saying? Like, so what the State Bar looks at is does this somehow violate the rules of professional conduct? The rules of professional conduct really deal with the relationship between the attorney and his client, or the attorney and the court. And they don't deal with attorneys making statements that you don't happen to like on the internet. So I'm sorry, but the First Amendment applies to attorneys. I know you're a big brain constitutional scholar and everything, but yes, even attorneys have a First Amendment right. And if the California State Bar, which is a branch of the government, it is enacted by the California State through Business and Professions Code, somewhere around 68,000 or something like that, 6,800. I don't remember exactly where. 6800 and maybe an extra zero, somewhere in there. But anyway, if the state tries to chill the free speech of attorneys, that that would be in violation of the First Amendment. So, you know, good luck. Have fun. I don't know what it is. I don't know what it is, why this particular generation seems to want to run to an authority figure every time somebody says or does something they don't like. It's like, it's the whole Karen response, let me talk to your manager. I can't deal with you. Let me talk to your manager. You know, it's that whole mentality. Chillie's a Karen. He didn't like me analyzing his lawsuit. So now all of a sudden he's going to say that I cyberbullied him. So that's pretty cool. That's pretty cool. Anyway, so back to this little video. This caught my attention because of some of the statements he made. So we're going to go through it. I have it sped up. I'm actually going to speed it up. No, I can't speed it up more. Damn it. Anyway, we're gonna go through this, and I'm not gonna stop it too often. Hopefully, but I have more a clearer picture right now since he wanted to make it personal about me. I have a clearer picture now about what's going on, and I'm gonna clarify a few things, as it were.
Good to see you guys, man. And just so you guys know, there have been a couple people. You guys saw my sales. So you guys saw my sales, right? $300 in August. So now let me just show you I mean, it is what it is. So here's my projected earnings for right now. Right there. See it? There it is. So there's my estimated revenue. So just so you know, there's been a few people who are in this chat now that if they didn't come through and send me financial support, I wouldn't be making it right now.
I just want to point out the dichotomy of him sitting in I believe it's a $6.6 million apartment in Boston on the 59th floor of a building, and complaining about his income while he's wearing Bose headphones, listening to nothing. Apparently, he's not playing anything or listening to anything, but he's got Bose headphones on. So that's just weird. Am I the only one who thinks that's weird? Are you going to sue me for saying that it's weird that you're wearing Bose headphones in a $6.6 million apartment, Chillie, while you're complaining about not making enough money?
There's no easy way to say that. You guys saw that my $300 August, and then you guys see from YouTube, I'm about $1,200 here. So if you do 300 plus 1,200 is $1,500 for a month. You really can't make it on that amount of money. And so,
somebody was insulting me earlier today as I'm sitting in my house on 10 acres, and I make a fairly reasonable amount of money every year. I had to pay a shit ton of taxes last year, so I'm probably gonna have to pay a shit ton of taxes this year because I worked my balls off. But anyway, I'm sitting in my house, and I'm enjoying some of the finer things in life. I've got a little snifter, whatever you want to call it, a thing full of not full. I've had a little bit of it, but I've got a nice bourbon in there, and things are good. I'm not sitting there looking at my income streams, pooping myself here, Chillie. And you know what? If you are pooping yourself because of your income streams, then you probably shouldn't be spending like $400-ish filing federal lawsuits. I'm just saying that maybe you want to rally your resources, and I don't know. McDonald's is hiring.
There's been a couple people in this room here today now who have reached out to me and supported me and during the really hard times. And you guys are going to find out on Tuesday exactly the extent of how far this has gone.
I think he's been taking his lead from Earl. You're going to find out later on. I can't tell you what I'm going to do today. You're going to find out later. What is it with every single one of these grifters, these charlatans, these hide the ball people? I don't get it. Like just say what it is, bro. Like it. There's no mystery. There really is no mystery. I always assume that they're lying and full of shit. What's his name? Grisham, Tiny Grisham, the chicken hawk. I'm not going to say what my state bar number is. I'm not going to say what my attorney status is. You've got to figure it out. Oh, why? Oh, because you can't actually come out and say directly, I am admitted into the Texas State Bar currently. You can't say that. So you got to play these stupid games. Like it's so stupid and simple. Earl's whole, I've got this flash drive full of information that I've sent off to my attorney, and he's going to turn it over to the Justice Department. It's stupid, and nothing ever came of it. And then the backtrack later. And this guy, and who's that Q You know, trust the plan. I mean, it's all the same bullshit. Like, if you start seeing the patterns, people, it will help you. See the patterns. If they can't just show you right then and there, if they can't show you, then they probably got nothing.
Tuesday, you'll find out how far this has actually gone. Because on Tuesday, I do something else that's even more. I'm doing something more on Tuesday. This is, just you guys.
I'm doing something more. More than what? More than filing a lawsuit? A sketchy lawsuit that has fairly dismal chances of success? And even if you do succeed, your odds of recovering a penny on it? Winning a lawsuit is one thing. Winning a lawsuit is the easy thing. Recovering the money is the hard thing. Recovering the money, that's why people love to sue. Attorneys love to sue businesses that are insured and people that are insured. So, you know, car accident, awesome. Totally, we'll sue for that because the insurance company is going to pay. If you're gonna sue if someone gets in an accident with an uninsured motorist, okay, you know, does your insurance company have uninsured? Do they provide you with uninsured motorist coverage, or did you decline that? Oh, you declined it. Well, good luck. We're not gonna sue the uninsured motorist. How are we going to recover? How are we going to recover? Even if we win, how do we recover? How do we get the dollars? A judgment is a piece of paper. How do you get the dollars? That's why attorneys, generally speaking, don't take defamation lawsuits on contingency. I've never seen one do it. I mean, maybe there's like the perfect defamation case out there where an attorney would take it on contingency, but good luck.
No, this is only one part of what I'm doing.
Notice how he puts it up to the window so you can see his view. Aren't you jealous, people? Aren't you jealous of his view? He's an alpha male. It's not his apartment, but he's an alpha male. He's only making $1,500 a month, but he's an alpha male.
This is only one part of what I'm doing. There's a second part I'm doing on Tuesday. Kate, on Tuesday, I'm hoping that that's the last day that we have to talk about this because I'll put an end to it on Tuesday.
I'm sure Kate's just shitting her britches right now. Just gallons of poop leaking out of her butthole right now, thinking about you putting an end to this on Tuesday. The big man who liked to shoulder check her in public.
Tuesday. I'm hoping on Tuesday. So I'll let you guys know what happens on Tuesday, but this is only one part of the plan.
Oh, why don't you let us know what happens on Tuesday? But it's only one part of the plan, he says.
You guys remember the other day I put up a video of David Goggins? And he said, when you start to attack, you keep attacking until your enemy is obliterated. So this...
I don't remember that because I didn't watch it. And I wonder if anybody else did. The other day, David Goggins, let's see. David Goggins. I don't see anything about David Goggins the other day. Wow, those views are pretty bad there, buddy. 1.1K views from the other day. Whew. You're messing down. You're down around in my territory of views. I mean, Lord, you're down in alpha or beta male views. Is that what you call me, a beta male or a mega male, whatever? You're down in my territory, buddy. That must suck.
This is only one prong of the attack. There's two more prongs against Kate and Josh. And
two more prongs. You know, there is this little thing where when you file a lawsuit, you actually have to like file a lawsuit for all of the claims that you have against that person that are known to you at that time. You can't parcel them out. You can't sue for defamation today and a different defamation tomorrow and a completely third different defamation the next day. They all gotta be in the same lawsuit there, constitutional expert guy.
Everybody else I'm suing. But Kate and Josh, the second prong.
Everybody else I'm like, ooh. Oh, those are all going so well, aren't they? How's that Ironton one going for you, buddy? How's that Ironton one going for you? You still winning on that one?
Comes on Tuesday. The third prong comes after that. I'm going to attack.
Oh, and then there's a third prong. Ooh. Why not a fourth prong, Chillie? How about a 57th prong? How about a 69th prong? Ooh, 69.
Attack and attack and attack until I take them down.
Attack. I'm going to attack by filing papers. Vexatious litigant. How do you spell that?
So you got my attention. You wanted it? You got it. So
I have your attention. I want it. Can I get more? Do you want to file that lawsuit against me? Because you're a California resident. I don't know if you own any property here. It's so much easier to collect on someone if they have property. I doubt you do, but you know what'll be interesting? What'll be interesting is you're a California resident, and I don't know why you're not in California, but I seem to recall something about you not being able to be in California. I could be wrong. I could be wrong. I seem to recall something about you being on the run from California, like you're on the run from Ohio. I don't know what it is. Yeah, I don't know what it is. Anyway, so it'd be interesting to get you back into California because, yeah. Go ahead and sue me, Tiger.
that's where it is. That's where it is. That's where it is.
Is that where it is, Chillie?
Great. I don't care, dude. I don't care. I don't care.
Blocking someone. Alpha male. I block people because I'm an alpha male. I don't care. Well, absolutely you do care. You just blocked someone. That's how much you cared. You cared enough to block them.
It doesn't matter because they have to prove their lies. They have to prove multiple lines of credit. They have to prove a Ponzi scheme. They have to prove that I do things wrong. They have to prove that I have victims.
Well, they do. They have to prove. What? 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 This is you may know this guy Bill Cosby. He was sued for defamation, and crazy enough, he was sued in Massachusetts. I think he lives in Massachusetts. Don't really know. Don't really care. But the fun thing about this case, and the only reason why I'm bringing this up, is because of this little section right here, choice of law. This little section right here. And see, what federal courts do, federal courts sitting in diversity apply state substantive law and federal procedural law. Sweet. The court determines which state law applies by applying the choice of law rules of the forum state, in this case, Massachusetts. In tort cases, Massachusetts courts consider choice of law issues by assessing various choice influencing considerations, including those provided in the Restatement Second of Conflict of Laws, 1971. Pursuant to Section 150 of the Restatement Second of Conflict of Laws, the law of the state where the defamed person was domiciled at the time of the publication applies if the matter was complained of was published in that state. So Chillie would be the defamed person, allegedly defamed, I should say. I'm not saying that Kate or Josh defamed him, but allegedly. Chillie is alleging that he is the defamed person. So what state is Chillie domiciled in? Well, if I remember from his complaint, he says that he is a citizen of, he's domiciled in California. Crazy. Crazy. The statements at issue in this case were published nationally. Oh, well, you know what? The statements that Josh and Kate made, they were also published nationally. Their YouTube went out. I saw them here in California. So they were published nationally. So the court applies the law of the state in which each plaintiff was domiciled when the alleged publication occurred. Now, where was Chillie domiciled? He's the plaintiff. Where was he domiciled when the alleged publication occurred? He was domiciled in California. And you know what? California has this little anti-slapp law. Now, for those of you who are paying attention, Massachusetts also has an anti-slapp law. Now you're going to ask, John, I know you're a fancy first-year family law attorney, but you're not a fancy first-year federal Massachusetts family law attorney. And I'm not. But you're going to ask, what's a SLAPP law? What's an anti-slapp law? Well, SLAPP, S-L-A-P-P, stands for Strategic Litigation Against Public Participation. The thought is that that people don't like to hear other people's opinions. And sometimes they want to abuse the system. They want to abuse the court system and try to silence people by filing lawsuits against them for things like defamation. And so what an anti-slapp statute is that it kind of reverses the burden of proof. It says, okay, sweet, you're suing me for defamation. I'm going to file a motion to dismiss based on an anti-slapp statute. And so now it's your burden. You have to prove that you can prevail. It shifts the burden from the defendant having to prove, for example, that you lied, to you having to prove that you'll prevail. Now you're going to say to yourself, maybe I'm not a federal Massachusetts first-year family law attorney, but I know that the district courts of Massachusetts have determined that they don't apply Massachusetts anti-slapp statutes. Well, you're right, they don't. However, the Ninth Circuit does apply California's anti-slapp statute. So, what California's anti-slapp statute does is if all the defendant has to prove is that the alleged speech, the defamatory speech, was about or concerning a matter of public interest. And I think it is. I mean, I've been told, reliably told, that our boy Chillie here is winning, whatever, the Grifty Awards, 2022 Grifter Award. The Grifties. Let's see what we got here. My awesome internet connection. Pulling through. Chillie de Castro. Whoa. What? What? You know, I'm going to go ahead and vote for you. Oh, I could only vote once. But anyway, I voted for you. Wow, Nick Rekieta. I don't watch him. Sticks, X, and Hammers. Cat, okay. The Quartering, yeah, I can see that. Ooh, Bobby Law, there you go. That's a good one. Amber Heard, Tim Pool. Yeah. 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 Oh, yeah. Definitely, yeah. 3 votes remaining. I don't know a lot of these people. Oh, he is. Oh, he is. And sure. All right. So now you know a little bit more about me by watching me vote for people. But yeah, look at that. Look at that. So you, sir, are a matter of public interest. You're a public person. You're a public figure, I should say. You're not a public official. You're a public figure. And when you're talking about your meteoric rise, that indicates that you're a public figure. When you have Getty's Images. Getty Images. Jose D. Small D. Castro. Images. Chillie? I swear I saw him. That's pretty cool. Maybe it's just Chillie. Maybe with quotes. I thought I saw him on some like red carpet or something. MySpace. Here we go. He's on like a red carpet. Getty image. That's what I saw. He's on a red carpet somewhere. And I don't know where. I don't know what that is. But that's your boy Chillie DeCastro on on a red carpet somewhere. That kills me. Oh my God, you're so alpha, bro. You're so alpha. All right, I'm sorry. I have digressed somewhat. Anyway, let's go on with this.
Victims, and they can't. Apology is not going to be good enough. I want to take their channels down. That's what I want to do.
He wants to take their channels down. So it's pretty clear. It's pretty clear from what he's saying that the purpose of this is to take away their speech. So it's let's get into what he'd have to show. This is from Herring Networks Incorporated. This is the OAN, something like One American News, or I don't remember what OAN stands for. Let's see if it says up here somewhere. One America News Network, OAN. Okay. So the threshold question in a defamation claim is whether a reasonable fact finder could conclude that the contested statement implies an assertion of objective fact. If the answer is no, the claim is foreclosed by the First Amendment. This is because pure opinion, that is, statements that do not imply facts capable of being proved true or false, is protected. To determine whether a statement implies a factual assertion, the court must examine the totality of the circumstances in which the statement was made. First, the court looks at the statement in its broad context, which includes the general tenor of the entire work, the subject of the statements, the setting, and the format of work. Second, the court considers the specific context and content of the statements. Specific context and content of the statements, analyzing the extent of figurative or hyperbolic language used and the reasonable expectations of the audience in that particular situation. Finally, the court considers whether the statement itself is sufficiently factual to be susceptible of being proved true or false. Whether an allegedly defamatory statement is one of opinion or fact is a question of law. It is for the court to decide whether a statement is actionable defamation in the first instance as a matter of law. But if a statement is susceptible of different constructions, one of which is defamatory, resolution of the ambiguity is a question of fact for the jury. The court now turns to the three factors under the totality of the circumstances analysis. A. Broad context. Context can be determinative that a statement is opinion and not fact, for the context of a statement may control whether words were understood in a defamatory sense. The court first considers the medium in which the statement was made. Maddow, as in Rachel Maddow, made the statements on our talk show segment that aired on MSNBC. The more statements lack the formality and polish typically found in documents in which a reader would expect to find facts, the more likely the statements are non-actionable opinion. And he's citing Unsworth v. Musk, finding that the general tenor of a made-for-television movie or docudrama tends to negate the impression that the statements involved represented a false assertion of objective fact. Also, Cochran v. NYP Holdings, noting that the alleged defamatory statement was located in a column in the section of newspaper that generally contains opinion columns. And if we apply this to what Kate and Josh did, they were on YouTube on panels discussing a person that they had a general distaste for. The court may consider whether the forum is one where a reader would where a reader would be likely to recognize that statements generally represent the highly subjective opinions of the author rather than assertions of verifiable objective facts. My dog was sitting on my cord, and that was irritating me, so I apologize for the stilted reading there. On one hand, a viewer who watches news channels tunes in for facts and the goings-on of the world. MSNBC indeed produces news, But this point must be juxtaposed with the fact that Maddow made the allegedly defamatory statements on her own talk show news segment, where she is invited and encouraged to share her opinions with her viewers. You know, I'm pretty sure that Josh and Kate are invited and encouraged to share their opinions with their viewers. At least according to plaintiff, viewers who watch MSNBC may know that it carries a, in quotes, liberal message, end quote, and that Maddow is a, in quotes, liberal television host, end quote, who expresses her views regarding Russia and President Trump. You know, I'm sure that viewers of Kate's live stream are aware that Kate is anti-Chillie, and that she expresses her views regarding Chillie. Maddow does not keep her political views a secret, and therefore audiences could expect her to use subjective language that comports with her political opinions. Thus, Maddow's show is different than a typical news segment where anchors inform viewers about the daily news. The point of Maddow's show is for her to provide the news, but also to offer her opinions as to that news. Therefore, the court finds that the medium of the alleged defamatory statement makes it more likely that a reasonable viewer would not conclude that the contested statement implies an assertion of objective fact. The court now turns to the segment as a whole. The, quote, general tenor, end quote, of Maddow's segment is a report on the Daily Beast article, and Maddow's tone could be described as surprise and glee at the unexpectedness of the story. I wonder if Kate's tone had surprise and glee. I wonder, did Josh's tone have surprise and glee at the unexpectedness of the story? She begins by calling the story the single most sparkly story in what had been a more ridiculous than most day in the news. She calls the news one among the giblets of the news gods dropped off their plate. The giblets the news gods dropped off their plates for us to eat off the floor today. Maddow reports that OAN shares staff with the Kremlin and discusses the allegedly defamatory Russia connection, then follows this by saying, while laughing, I mean, what? She concludes the segment by saying, with a shake of her head, I mean, this is the kind of news we are supposed to take in stride these days, and we do our best. A holding by the Ninth Circuit in Partington is applicable and worth quoting in full. When, as here, an author writing about a controversial occurrence fairly describes the general events involved and offers his personal perspective about some of its ambiguities and disputed facts, his statements should generally be protected by the First Amendment. Otherwise, there would be no room for expressions of opinion by commentators, experts in a field, figures closely involved in a public controversy, or others whose perspectives might be of interest to the public. Instead, authors of every sort would be forced to provide only dry, colorless descriptions of facts, bereft of analysis or insight. There would be little difference between the editorial page and the front page, between commentary and reporting, and the robust debate among people with different viewpoints that is a vital part of our democracy would surely be hampered. This is true here too. Maddow fairly described the article that formed the basis for her segment, and she added in her colorful commentary and opinions. Viewers expect her to do so, as it is indeed her show, and viewers watch the segment with the understanding that it will contain Maddow's personal and subjective views about the news. Thus, the court finds that as a part of the totality of the circumstances, the broad context weighs in favor of a finding that the alleged defamatory statement is Maddow's opinion and exaggeration of the Daily Beast article, and that reasonable viewers would not take the statement as factual. Specific context. By the way, this is all part of the Rachel Maddow filed an anti-slapp motion and Herring Networks is defending the anti-slapp motion and losing. B, specific context. The court now considers the specific context. Even where the broad context is one of opinion, it is possible that a particular statement may imply an assertion of objective fact and thus constitute actionable defamation. In analyzing the specific content and the content of the statements, the court analyzes the extent of figurative or hyperbolic language used and the reasonable expectations of the audience in that particular situation. Where the language used is loose, figurative, or hyperbolic, this tends to negate the impression that a statement contains an assertion of verifiable fact. A hyperbole is an exaggeration, especially to an excessive degree or in a manner of speaking that depicts something as being much bigger, smaller, worse, etc., than it really is. Hyperbole, from Black's Law Dictionary, 11th edition, 2019. Hyperbolic statements are not actionable because the listener knows that he or she should not accept the statements as fact. See Eric Fulcher, Rhetorical Hyperbole and the Reasonable Person Standard, drawing the line between figurative expression and factual defamation. The primary rationale behind precluding liability for statements that qualify as rhetorical hyperbole is that the listener or reader knows that the statements are not to be taken literally, and therefore such statements do not damage the subject's reputation. A main issue here is whether Maddow's statement was hyperbolic, because Maddow used the word literally, in quotes, i.e. OAN is, in quotes, literally, end quote, paid Russian propaganda. Plaintiff asserts that it would be unreasonable to find the statement to be hyperbolic. What is noteworthy about the word literally is its conflicting definitions. The first definition of the word is in a literal sense or manner, such as in a way that uses the ordinary or primary meaning of a term or expression, or used to emphasize the truth and accuracy of a statement or description. But the alternative definition is, in effect, virtually, used in an exaggerated way to emphasize a statement or description that is not literally true or possible. Further, under either definition, the term can lose its meaning when considered in context. Although Maddow used the word literally, this does not necessarily mean the phrase should be taken to be factual. Nowadays, as evidenced by the two conflicting definitions of the word literally, use of the word can be hyperbolic. The court must therefore consider the language surrounding the alleged defamatory statement to put into perspective the content of the statement. This is where our boy Chillie is going to have a hard time, because all the statements that he alleged that Kate and Josh made had a context to them. Bourbon. There are certainly facts presented in the segment that are not in dispute. It is undisputed that the Daily Beast article was published, wherein the author Kevin Poulsen opined that Christian Rose has been reporting on U.S. politics for OAN and simultaneously writing for Sputnik, a Kremlin-owned newswire. I'm going to say Roz, is a Russian national on the payroll of Sputnik. Poulsen then detailed a few of Roz's reports for OAN, pointing out that Kremlin propaganda sometimes sneaks into Roz's segments. Poulsen found no disclosure by OAN of Roz's work for Russia's state-owned media, where he continues to file stories daily, primarily on economic news. There is no dispute that Maddow discussed this article on our segment and accurately presented the article's information. Indeed, the facts in the title of her segment are not alleged to be defamatory. Staffer on Trump-favored network is on propaganda Kremlin payroll. Plaintiff agrees that President Trump has praised OAN, and Roz, a staffer for OAN, writes articles for Sputnik News, which is affiliated with the Russian government. Roz is paid for his work by Sputnik News. Maddow provided these facts in her segment before making the allegedly defamatory statement. The Ninth Circuit has held that when a speaker outlines the factual basis for his conclusion, his statement is protected by the First Amendment. You know, when Kate outlined the factual basis for her conclusion, her conclusions, plural, that transformed her statement into something that's protected by the First Amendment. When Josh outlined the bases for his assertions, that again transformed his statement to be one that's protected by the First Amendment. Citing Partington, citing Dodds, holding an opinion based on an implication arising from disclosed facts is not actionable where the disclosed facts themselves are not actionable. A statement of opinion based on fully disclosed facts can be punished only if the stated facts are themselves false and demeaning. When the facts underlying a statement of opinion are disclosed, readers will understand they are getting the author's interpretation of the facts presented. They are therefore unlikely to construe the statement as insinuating the existence of additional undisclosed facts. The basis for Maddow's allegedly defamatory statement is clearly the story from the Daily Beast, which she presents truthfully and in full. Thus, she sufficiently provides listeners with the factual basis for her statement. Maddow does not even hint that her opinion is based on any additional undisclosed facts not known to the public. A statement of opinion may still be actionable if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. Viewers were presented with the details of the story before hearing the alleged defamatory statement, and no additional facts were implied. I'm going to skip. All right. Now, finally, we're down to the susceptibility of being proven true or false. The court last considers whether the statement is susceptible of being proven true or false. In Unsworth v. Musk, the court evaluated a plaintiff's defamation suit against Elon Musk, brought because Musk had issued a tweet calling the plaintiff pedo guy. In evaluating the plaintiff's defamation suit, and specifically under the factor of susceptibility of the statement being proven true or false, the court found the defendant's tweets were susceptible of being proved true or false because plaintiff either is a pedophile or he is not, and if he were, evidence could prove it. Further, in the Ninth Circuit, Yagman discussed the plaintiff's use of the term dishonest when describing a judge, and the court found that the statement was of rhetorical hyperbole, incapable of being true or false. In contrast, the plaintiff's statement that the judge was drunk on the bench was one that implies actual facts that are capable of objective verification, concluding that defendant Rooney's opinion that a windshield treatment product did work was based on factual observations to a sufficient extent to imply an assertion of fact. Also Cochran asking whether there is any core of objective evidence upon which the court could verify the allegation. Here, taking an isolation statement that OAN is literally paid Russia propaganda is capable of verification. Either OAN receives money from the Russian government or does not. Thus, this factor weighs in favor of finding viewers could find or could conclude that the statement implied an assertion of objective fact. And then when the court weighed it out here, the court found in favor of Maddow. So what is this saying? He was claiming that he didn't have to prove these things, but he will, in order to prevail on the anti-slapp motion. The Ninth Circuit treats it as a 12b6 motion to dismiss, but it is still anti-slapp. So the burden shifts to delete laws to prove that he could prevail.
I don't care about the financial gain. I want their channels down. So that's called equitable relief. But we're actually, I can't say anything.
So equitable relief, yes. Wanting their channels down is equitable relief. You have to ask for that specifically. If you ask for an attorney, which he did in his civil case cover sheet, and he did not in his complaint, I don't know how a court would deal with that. A court may say, fine, you've kind of asked for it, you've put everybody on notice, go ahead and pay the jury, pay for the jury, and we'll go ahead and proceed with the jury trial. But if it is a jury trial, you can't get equitable relief. If you're seeking equitable relief, it is a bench trial. If you're seeking relief under law and equity together, that's also a bench trial. Equity, anytime you're asking for equity, it's now a bench trial. If you're just asking for money, that can go to a jury.
Anything else? I'm gonna button it up now. I'm just not gonna say anything else. I'm just gonna do.
Are you not going to say anything else? Everybody, make your bets right now as to whether or not Chillie's going to say something else.
But on Tuesday, another shoe will drop.
He got to on Tuesday. You said something else.
These people will have to deal with the consequences of when you get a legal scholar and you piss them off.
A legal scholar. Wink. You know, there are a bunch of charlatans who call themselves reverend and things like that. Things that you don't have to actually have any real proof of. I mean, anybody can call themselves a reverend. And anybody can call themselves a legal scholar. But where did you study, Chillie? Where did you study? And didn't you used to be a constitutional scholar? Now you're a legal scholar? It's weird. It's weird that you're filing all these lawsuits and making such basic mistakes.
Let's see what happens. So they won't be able to. No, they won't be able to. No, they won't be able to. So
I'm pretty sure they will be able to prove you have a criminal record, considering that the court in Massachusetts, the state court in Massachusetts, found that you had that arrest for GHB, something, some sort of an arrest. I thought it was for GHB. It could have been some other kind of drug, manufacturing with intent to distribute it, I think it was. And then there's also the petty theft arrests. I think there's one arrest in Oregon. I think there was also, you arrested for driving without a plate or driving with stolen plates, but I don't remember what happened with that. And I thought there was something out of Alaska too. Anyway, never underestimate the ability of the autists on the internet to find your, in quotes, hidden, end quote, criminal history.
you guys, I need there's 350 people in here. Do me a favor, go to my last 5 videos and just put the like button, please.
350 people were watching your live stream, huh? 45.8 thousand subscribers, and you had a whopping 350 watching your live stream? That's not so good.
They're hurting my ability to get out to the public. So please go to my last videos and push the like button if you would, please. If you would, pretty please. They're hurting my subscribers are following, my views are following, because they're streaming by Kate's order, streaming my videos on back channels to deny me prosperity. Kate, you
streaming his videos. I don't think there's really enough interest in his videos to justify streaming them on a quote back channel, end quote. And why don't you copyright strike those back channel, end quote videos?
dumb shit. You shouldn't have written those things in your Discord because I got the screenshots. That doesn't come right now, Kate. Just wait, Kate. You want to get into the labyrinth of legal things? Welcome to it. You have
Again, you have to bring all of your claims at the same time. You got to bring them all. You can't piecemeal them out, bro. So if you have other claims against her, you've got to file them now. There's no you wait. It's you amend your freaking complaint and you add those claims to it. There's no wait. Amend your complaint, add those claims, and then, do the alpha male thing and serve her.
I have no idea what I'm doing next. You're gonna find out, though. You're gonna find out.
No one has any idea what you're doing next because you're not acting rationally.
You're gonna find out. You're gonna find out. You're gonna find out. I'm gonna do.
Are we gonna find out? Does anybody think we're gonna find out?
Every single legal maneuver I can to get that chick's channel taken down and Josh's taken down. But for now, I gotta worry about what I'm doing over here. So.
Anti-slapp. Blocking someone else.
Defamation is not just disagreeing with me. Defamation is when you make up things about me that hurt my future prosperity for the rest of my life. Remember, I'm an entrepreneur. I've raised money consistently my entire life. So if you make up videos about me saying I run Ponzi schemes and I cheat investors.
He's raised money his entire life, but has he made money? Don't entrepreneurs make money? I thought they made money. What do they call those capital investors? Or there's a term for somebody who raises money for corporations. I forget what the name of it is. But it's not on entrepreneur.
That's a way to hurt me. If you make videos about me and say that I have victims of violence that I've hurt and you're just protecting them, that hurts my reputation for the rest of my life.
Well, I believe I have seen something that appears to be a domestic violence restraining order against you out of California, sir. And while technically it does not take physical violence to get a domestic violence restraining order in California, that's one of the easy ways to get it, is to be physically violent.
And if you have 400 to 500,000 subscribers and you say that, then you're going to get sued. There it is. Welcome to it.
4 to 500,000 subscribers. Do I have 4 to 500,000 subscribers? I hope I do. Please God, let me have that. I want to be sued. Your channel? My channel. Your channel. Shit. I need, if you guys can get me another 220 subscribers so I can get sued by Chillie, I'd appreciate that.
All right, I'm where I'm at, I'm where I'm at, so.
Maybe I should buy subscribers. I know some people out there have bought subscribers before. I mean, I don't know any person in particular who's bought subscribers, but I know some people out there have bought subscribers before.
So, you're going to have to deal with it. I just read off the list. Every single thing they said about me is a lie. There's not a single thing. It is what it is,
Well, if you say it's a lie.
Oh, okay. I'm just trying to catch up with the chat here. Blood pressure's a little lower, I think. I haven't been tested in a minute, but I'm just trying to smoke weed and take it easy. Light on the weed.
Yeah, I think you should maybe stop smoking weed, bro. You're only making what was it, $1,500 a month? Maybe you shouldn't be blowing your money on weed.
1 cup of coffee in the morning. I think I had 2 cups today. Don't tell anybody. I think I had 2 cups of coffee today. But I gotta fight back eventually. It's like I know that I get this mean on my face and I get like really aggressive and mean. And I'm mad and I'm pointing and I'm angry. I'm pointing at the camera. And it's like it just when you get lied about and then that dumb shit Josh saying that my cousin. You don't think my cousin's gonna go into a deposition? You don't think that my friend is gonna say he never kicked me out of my house? I've never stayed in a hotel. Like what are you talking about? We woke up in the morning, had a cup of coffee and a walk, and I said have a good day.
It doesn't matter. It doesn't matter what they say. It matters what they told Josh. And if this goes to an evidentiary hearing, a trial, as it were, and Josh testifies that your cousin said these things to Josh, then whether or not these things actually happened to Josh, if the jury or the judge, whoever the trier of fact is, believes Josh, then that's it. His testimony is evidence if he testifies.
Dumb shit. Like you can't say I paid for his hotel. Here's the receipts, and then forget to say that I paid for the hotel. Like he's just crap.
Well, I guess he can because he did.
The transparency website's not up yet, but it is what it is. Thanks, Patricia. I appreciate it. I appreciate you guys. Thanks you guys for coming by. I've been on here for almost 2 hours. I didn't plan on being this long, but I just wanted to, I wanted to show you guys these documents. I wanted you guys to see them for me and realize the reason that I'm suing is because every word they've said about me is a lie, and that's why I'm suing. That's why every word's a lie. And their troll mafia has hurt my channel. It's hurt my views. It's hurt my reputation. It's hurt my finances. It's hurt my right to prosperity. It's hurt my right to travel.
I just wonder if the things that you have done, Chillie, have hurt your prosperity. And how would they hurt your right to travel? I mean, I know you can't go back to Ohio for a while because of the bench wart and everything, but how do they hurt your right to travel? That's really weird. Or are you just trying to allege violations of your constitutional rights? How would they affect your right to travel? But anyway, I've been watching a couple frog videos lately with you palling around and agreeing with like a batshit crazy Sovsit, that Paul Unslaved or whatever the hell his name was. The dude was crazy, just throwing up word salad, just all sorts of stupid shit. And you're like just nodding your head and agreeing with him. Yeah, why don't you try driving without a driver's license and without plates there, Chillie? You seem to be in so much agreement with him. How about you try to implement his little strategy?
To travel around the country, it's hurt me. It's hurt other areas of my life that I'm not revealing yet. They'll come out on Tuesday. So,
I wonder if you can't get it up now without thinking about Kate.
Yep.
A little erectile dysfunction, maybe.
So anyway, all right.
He just blocked someone else.
I could sit here and talk to you guys all day long, but I'm going to try to get this video put together, and then I have something coming out on Tuesday. I'm going to let you guys
try to get this video put together. Like you live streamed it, bro. Like you put it together. I don't even know what that means.
know what happens on Tuesday, but the other shoe drops on my attack. I'm going to attack these people legally, and the other shoe happens on Tuesday. So you guys can look forward to
the other shoe happens tomorrow. 2 days. 2 days from now. Tomorrow is a holiday.
that. Thanks for coming by, everybody. I do appreciate it. We don't stop. Can everybody put that in there? Just type in there real fast. We don't stop. We don't stop.
You know, sometimes stopping is the smart thing to do. When, you know, if you're in a hole, the classic saying is stop digging. Anyway, I've wasted enough of everybody's time. Thank you for watching. Have a great day.